So our next speaker is David Muraskin, and you should know him well. He's represented RCAF for many years, actually. It first involved a country of origin labeling case. If you recall, David Muraskin at the time was working for public justice. I'm sorry. And as a public justice attorney, they were supportive of country of origin labeling. We were the plaintiff. We filed a lawsuit alleging that USDA's improper use of the Product of USA label was unlawful. And the court ultimately determined that because the rule by which the USDA was allowing the mislabeling of beef was passed back in the mid 1990s, the time statute had expired, that we were barred from taking the case on because we hadn't filed a complaint during the required time frame that we were supposed to file. But then we began work on the beef checkoff program, and we alleged that the state beef councils were violating the Constitution because USDA was allowing them to use your mandatory checkoff dollars to fund and subsidize private speech, which is a violation of your First Amendment rights not to be compelled to subsidize private speech. And in that case, if you recall, the magistrate judge in the case agreed with us, and so too did the court. And in response, the USDA immediately entered contracts with all the state beef councils, essentially assuming full control over every message expressed by the councils. As a result, the USDA argued that they had converted what was private speech into what is now government speech, and government speech was not protected by the Constitution. So the government can compel you to fund government speech, and you know that to be true because you pay taxes every year to help fund the government. So as a result, we filed yet another lawsuit. We alleged that when USDA entered these memorandums of understanding, the contract assuming control over the state beef council speech, that in that process, the government failed to go through the required comment and notice period, otherwise known as a rulemaking period, to give you, the producers, an opportunity to comment and to make recommendations and changes. Instead, the USDA unilaterally entered into these contracts. Well, similar to our EID case right now, where the government argued we don't have standing, that was the argument by the government, and they prevailed. That the District Court of Columbia ultimately determined that we did not have standing to bring the case, and so they recommended to us that we file a petition. So David Muraskin now is a manager of FarmSTAND and still working on this case, though it is now over, and he's going to talk to us by way of video. He's not live, but he's going to talk to us about what the options are that we have in terms of pursuing yet a remedy under our beef checkoff long-term challenge. So with that, we'll begin the video with David Muraskin.
Hi, all. I'm really sorry that I cannot be there with you in person. I always enjoy spending time with the broader RCAF community, and I'm sorry I cannot make it out there this year, and also sorry that the schedule is such that I'm pre-recording this, so I can't even take some questions from you. But Bill will be available to answer anything, and I certainly am always available to talk through any issues that come up that you want to discuss related to the checkoff or where we can be helpful. But I'm here to provide you the update on what's going on with the checkoff litigation that RCAF has been pursuing for years. And to do that, I've got some slides to share with you that I'm pulling up as we speak. Hopefully you all are seeing them now. And they concern the most recent litigation that RCAF has been pursuing in federal district court in DC around the checkoff under a statute called the Administrative Procedure Act. But I'm also going to start with some background for those of you who just may need a reminder about where we've been over all these years. I think it's getting close to a decade now of litigation, so there's a lot of background to cover. When we started this litigation against the checkoff, the theory was that the checkoff itself was administered in an unconstitutional way, that the transfer of checkoff money from producers to the qualified state beef councils in particular was effectively compelling you to pay for other individuals' private speech. So the rule is that just like any taxpayer, you can be required to pay for the government speech. We all pay taxes, and I mean, the government can put out statements using those tax dollars, and that's not constitutionally prohibited. But the government can't force you to pay for your neighbor's activities or your neighbor's advocacy. And the QSBCs, although they've historically held themselves out to be quasi-governmental entities, in fact, have been private. RCAF has been locked out of being able to participate in QSBC meetings. They are functionally private entities, often directly tied to the Federation of State Beef Councils and also the National Cattlemen's Beef Association. The Federation is a quasi-government entity, but the National Cattlemen's Beef Association is certainly a private governmental group. And so the forcing to pay for this private speech of a private entity that's connected to a lobbying group is unconstitutional. That's what we won way back when in the District of Montana, and that prevented your money from going to the qualified state beef councils. USDA at that time responded with kind of a sleight of hand. It said, well, we're not going to actually change anything about how this money is being used or how this program operates. We're not going to reconsider the checkoff writ large. We're just going to create these, quote, memorandums of understanding with the qualified state beef councils that said that USDA would sign off on anything they did. And the question was that sufficient to convert the qualified state beef council's activities from private activities to government speech when they engage in advertising or engage in other advocacy with your beef checkoff dollars? And unfortunately, in decisions that I think are really poorly reasoned in terms of looking at kind of in terms of avoiding the underlying facts and focusing instead on kind of broad principles without looking at the nuances, both the district court and the Ninth Circuit held that those MOUs were sufficient to convert the QSBC's activities into government speech. So now simply by the QSBCs entering into these MOUs, the money could flow to the QSBCs again. They could basically engage in the same activities they had in the past. And we have seen functionally nothing really change with the QSBCs. USDA just now has two people sitting in an office somewhere that stamp approval on the QSBC activities. So what do we do about that? RCAF then said, well, the MOUs themselves are illegal, that the government entered into the MOUs directly as a response to RCAF's litigation. It didn't pause to think about whether the MOUs were a good idea or how they could be best structured. And traditionally, when the government's making new rules, it has to get notice, has to tell the public that it's doing something, and then has to get comment from the public on how the government's crafting the rule to make the rule as good as possible. And that's called notice and comment. And the idea was that if notice and comment existed, RCAF could argue for a whole host of limits on how checkoff dollars are spent, how QSBC activities are regulated, what QSBCs could engage in. Could they continue to be in partnership with the National Cattlemen's Beef Association and do the bidding of packers with checkoff dollars? We could articulate all these different sorts of limits on how the money should be spent. And so the idea was that without going through notice and comment, the activity was illegal. And if you got notice and comment, you would really be able to change how the checkoff was administered. Unfortunately, in a decision from a few months ago, the district court in DC ruled that RCAF lacked standing to bring that argument. I want to be very clear what it did not say. It did not say that the MOUs are legal. It did not say that the current administration of the beef checkoff program complies with the law. Standing is something that's reached before you reach the merits of a case. And what this district court said was it was not going to reach the merits by saying that RCAP didn't suffer a sufficient enough injury in order to bring the case forward. Importantly, a big basis of our theory of standing was that the checkoff could be administered in ways that benefit domestic producers better. In particular, we presented lots of evidence that if the checkoff was administered in a way that would differentiate between imported and domestic beef producers would benefit, that they would be able to sell their beef for more because consumers would appreciate that there were different segments of the market and seek out the domestic segment because we know consumers prefer domestic beef, and that would then increase your profits. That basically the checkoff, as it's currently structured and saying buy beef generally, homogenizes beef production, makes it into a generic product that consumers don't differentiate, and the beef checkoff could be much better run by differentiating the products and pushing consumers to purchase made in the USA beef, what they want to purchase, but currently they see the products as interchangeable and aren't told to demand US beef. The court took also no issue with that theory, that the checkoff could be better administered, that it could run in ways that would greatly help domestic producers more than it's currently doing, and that these minor changes really would still increase beef sales overall, but really focus on the domestic market. The court took no issue with that. It said it was going to assume that was true, that we had put forward evidence that suggested that, and it was not going to take dispute with that evidence. Instead, what it held was that because there was evidence that the checkoff does increase overall beef sales, even if it might not do so to the greatest extent for domestic producers, even if domestic producers might sell their beef for more money, even if that might increase overall beef sales more, because we couldn't show that the checkoff as it's currently administered decreases demand for beef. In other words, that there was an actual financial injury to you from the baseline of no checkoff, that it was going to say that there wasn't a sufficient injury. So I think this is an important point. So let me just kind of try to spell this out in another way. That what it said was that it was going to look at the world as if there was no checkoff and no QSBC, and as if there was a checkoff. And what we had to do was show that the existence of the checkoff as it currently is administered actually harms you. Not just that it could be administered better, not just that if you looked at how the checkoff could be administered and whether that would make you better off, and compare that state to the state that's currently administered. The court said that was irrelevant. The fact that you could be doing better in the current state is less good for you is not enough. You need to be shown that the current state actually decreases beef sales. And unsurprisingly, we did not have evidence of that advertising for beef generally increases beef sales, even if it doesn't differentiate among the beef product, even if it didn't, even if it fails to promote domestic beef as much as it could, beef advertising does increase beef sales. So in other words, that if we just took away all the QSBCs, it wouldn't say that taking them away that we couldn't say that taking them away entirely would make you better off, even though changing how they're administered would make you better off. And something that's important to highlight that Bill and I went back and forth a lot on is that there is a pre-existing rule that says the simple fact that you all pay for the checkoff doesn't mean it has to be administered in a way that benefits you the most. One would think that you paying your dollar in for every head of cattle means that you should have a special say in how the checkoff is administered, and that the checkoff should be specifically tailored to your interests. But the DC Circuit, in a case that well predates ours, said that that is not enough, that simply paying into the checkoff is not enough to establish an injury regarding how it's administered. So we had to show something besides that you paid in. We tried to show that if the checkoff was administered in a different manner, you all would benefit much more greatly. And the court said that wasn't the right question. The right question was, are you actively harmed by the current administration from the checkoff? In other words, does it take dollars out of your pocket, not from what could be, but from what is? That meant it never reached the merits. And so we don't have a ruling on whether the MOUs are legal. We still contend that the checkoff is administered in a legal fashion, but the court's saying it won't let us get there because we can't show a producer how a producer is harmed. Unfortunately, this leads you probably outside the courts for options, but there are a couple of active options to consider as next steps that can continue to pursue this checkoff fight. So one thing the court said you could do is you could ask USDA to change how the MOUs are administered. And this is important because for a number of reasons. One is that it changes what the nature of an injury is in court. If USDA turns down your request for the checkoff to be administered differently, and you can say that's arbitrary, that USDA didn't think about this program enough, didn't think about the consequences enough, to not consider all the potential interests at stake in the right ways, to not consider the balance, your interest versus international interest properly, that is an injury. So we no longer need to show financial harm once you petition. You can just say USDA, in refusing to change how the checkoff is administered, is failed to reason through the program correctly enough, and simply by having your petition denied and you saying it was denied for the wrong reasons means that you can pursue a case against USDA for failing to make those changes. That would open the courthouse doors again. The other cool thing about a petition is it's not limited to you saying the MOU should be changed. You can ask for lots of things. You can ask for whole-scale changes to the program. You can ask for changes not just to the beef checkoff program, but you can ask for changes to all the checkoff programs. You can ask for not just changes to how the states administer the program, but you can ask for changes to how the Federation and how the Beef Board and Beef Committee administer the program. And so that all can exist in a petition. You can get a lot of a bigger change. And again, you can sue over this this change in the failure of USDA to act on that simply by failing to reason through the issues the same way that RCAF does, or the same way that your coalition who brings the petition does. And I know that Secretary Rollins will be attending the convention this year, and so I encourage you to demand of her that she consider this petition when it goes through, that she listen to RCAF's complaints about the checkoff and listen to how it's impacted your lives, listen to its failures, and that she act on it. Because the best case scenario is not that you ever have to sue over a petition, but rather that the agency will act. And the checkoff is one of the things that the party in power right now has said that it wants to reform. And so I encourage you to hold Secretary Rollins' feet to the fire when she comes before you and get her guarantee that she will consider reforming the checkoff. She will look at your petition, she will analyze it, and hopefully she will act on it. If she doesn't, you should seek her back in court after you bring that petition. Another option, which we've talked about several times but is just coming back up, is the OFF Act, which again places limits on where money can go of all checkoff dollars, not just beef checkoff dollars, but not just the state beef checkoff dollars either. It places limits on how the Beef Board and Beef Committee can use the money, the true government entities here. I referred earlier to the Federation of State Beef Councils as a quasi-government entity. I think that was overstating it. It really is a private entity that feeds into the beef committee, and the beef committee is the bigger governmental entity and the beef board. And the OFF Act would limit where that money could go, prevent it from going to groups like NCBA. And it would prevent that across all sorts of checkoffs. And this is a bipartisan bill. You have Democrats like Elizabeth Warren and Cory Booker in on it. You have the senators from Utah in on it as well, Mike Lee. And there's a real bipartisan issue that brings people across the board together. And it's been reintroduced. And it could become part of the Farm Bill that Congress is currently considering. Often, bills like the OFF Act don't pass on their own. They pass as part of bigger vehicles. And so we're at a moment with the OFF Act where there's big bipartisan support and there's a vehicle for when which to pass. And this too could really reform the checkoff. And so the other thing I would encourage you to do is, I know you have representatives and senators speaking to you, and the question is, why aren't they supporting the OFF Act? Can they get on board and throw their support behind the OFF Act to be co-sponsors of the bill, to say that it should become part of the Farm Bill, to prevent your checkoff dollars from being abused by groups like NCBA. And that's another step that you can take. That one doesn't have litigation at the end like what we've been doing together, but would be a real means to reforming the checkoff program. And so these are the two next steps that I would encourage you to take. And certainly the petition is one that RCAF has a lot of expertise in, and we certainly would be interested in helping you with if you ever got to the litigation stage. But my hope is, with the people in power today, RCAF can say that there needs to be accountability for what they ran on, and they need to support these changes that they have committed to. As always, I am here if you need anything. FarmSTAND stands ready to be with RCAF in this pursuit to ensure that the law is followed, that this money is not being abused and administered in a way that promotes consolidation and takes money out of true farmers' pockets, putting them into industry that just pretends to be farmers. And we're here to help in any way we can. We look forward to working with you in the future, and we hope you can continue to make change through using that political capital that you've built by supporting those in power to make sure that they now follow through on what they've said. As I said, I'm really sorry I can't be with you there today, and I know that there may be questions from the audience. Bill, of course, is one of the world's experts on these issues, so he will be able to answer this better than I would, I'm sure. But I look forward to hearing from him what you all thought about what's going on and what the next steps are. Thanks so much.
So David Muraskin's presentation was recorded at the time where we were in fact expecting that Secretary Rollins was going to be here. She was trying to be here, and late last week we got the disappointing call that she would not be able to attend, and cited scheduling difficulties as the reason. So David didn't know that at the time that he had written his or recorded his video for us. We could do two questions if anyone has questions regarding David's presentation. And if not, or go ahead.
So my understanding of the checkoff, ever since I paid attention to it, I always felt like it was taxation without representation. And I know I've heard that a lot. But with them using switching to using the MOUs, saying, well, it's just like a tax, wouldn't that give us ground to say, okay, you admit that it is a tax, and then we could fall back on it being taxation without representation, because they said we didn't necessarily have the right to tell them what to do with the money. Does that make sense, Bill, what I'm asking?
Yeah. So we looked at all the angles that we could possibly challenge the beef checkoff on several years ago when we filed the first case. And the challenge that we brought was a constitutional challenge that this was, as you said, what do you say?
Taxation
without representation. We called it an excise tax. And indeed, what USDA was doing was compelling you to subsidize private speech. That was the issue. And so now that it's all government speech, we're back to taxation without representation. And not for, of course, I'm not an attorney, but you do have the Cattlemen's Beef Board that is appointed and is supposed to be the representation aspect of the entire program. They are supposed to be representing the interests of producers. And obviously that's not working. So our options right now, our best option and the most expeditious option would be to pursue the OFF Act that has now been introduced in both the Senate and the House. So that's going to be our focal point right now.
Thank you.
Okay, that was one. Another question over here. Mike. Does Mike have a mic?
Thanks, Bill. Mike Schultz from Brewster. The question is, we've been working on the OFF Act stuff on the checkoff reform, and I've been kind of pushing this issue for those of you that maybe have never read the act in order, but in the first paragraph, it says to enable the cattle producer to establish, finance, carry out, coordinate program research, producer and consumer information, promotion and improve, maintain and develop markets for cattle, beef, and beef products. Then as you go on down in the act, it talks about the United States and the nation where it can be used. My question is, if we've missed the legal part, is there, I don't know if anybody, has anybody in here raised a hand if you've ever seen an ad for the cattle industry paid for by the checkoff? Because I don't think I've ever seen one. And so my question is, the intent and justification in a court of law, it could be an illegal deal, and we may miss the point. But this is something I brought up to the legislators that's frustrating to us, Bill. So I don't know intent, justification. In summary, it says here, if something is specifically targeted or excluded, particular entities could face legal challenges based on principles, like a bill of attainder, a clause, or equal protection. I don't know where we go with it, but that's what I've been pushing in DC.
Okay. So I'm not sure what the document is that you're reading from. You weren't reading from the act or order, were you?
The second part, no, but the first
Okay.
part was the act.
So I'll just refer back to what I think is the most expeditious route for us at this point. And that the second would be the petition. And in the petition process, as David indicated, we would not be limited to just challenging the MOUs or attempting to amend the MOUs. We could amend the whole program, meaning the order that's associated with the act. And so we could address that potential issue, during that process. But at this point, we can't do it in the litigation. The litigation's over. And so we're now just shifting gears. As we work the three branches of government, now we're going to go back into Congress. We've left the judicial system. We'll go back to the legislative branch, and we will see if we can get this included in the Farm Bill. So thank you.